I'm Drew Stevenson. This is for my administrative law class. Here I'm going to be talking about the case West Virginia versus EPA. This is a 2022 U.S. Supreme Court case where they set forth sort of their modern jurisprudence about the Major Questions Doctrine in administrative law. So let's dive in.
I represent the Environmental Protection Agency, the 3rd District.
Great. We just had a visit from the Environmental Protection Agency.
So I want to give you just a little bit of the legal background here without going too far afield into environmental law. Basically, under the Clean Air Act, we have a section 111, that authorizes the Environmental Protection Agency, or EPA, to set standards of performance for stationary source emissions. In other words, that's like factories and power plants and the stuff that's coming out of their smokestacks. Standards must reflect what's called the best system of emission reduction, or BSER, that is, quote, adequately demonstrated. One thing to keep in mind about environmental law is it's full of acronyms like this, but we're going to talk about BSER throughout this case. Now, historically, the EPA had set standards based on measures to make individual plants operate more cleanly. In other words, these were technology controls like filters or scrubbers on their smokestacks and efficiency improvements inside with whatever was producing the emissions. And we call this in environmental law the technology-based approach. It really focuses on reducing emissions from individual sources or plants. Now, this case is really about something called the Clean Power Plan, or CPP, that came out in 2015 that was designed to address carbon dioxide emissions from existing power plants. And it departed from the kind of historical practice by including something called generation shifting in its BSER for coal plants. So we're talking about coal power plants and generation shifting. What do we mean by generation shifting? Well, this basically means that they have to shift some of their power generation to clean energy sources and to reduce the use of coal. In other words, they're going to have to sort of subsidize or shift to wind, solar, and natural gas. Now, the new emissions limits that were under the Clean Power Plan were pretty strict. They were so strict that they really couldn't be achieved unless a plant was going to shift some of the power generation to clean energy sources like solar and wind. The majority and dissent disagreed about whether this kind of broader conception of EPA's authority in the Clean Power Plan, in other words, the generation shifting, is within the scope of power that Congress granted in the Clean Air Act.
Why are you so obsessed with power plants?
Free clean energy for an entire city.
I'm kind of the only name in clean energy right now.
So let's talk about the holding in this case. This is Justice Roberts writing for the majority, and he holds that the EPA actually exceeded their authority under the statute, which made their Clean Power Plan that they came up with in 2015 invalid. So the majority found that Section 111 of the Clean Air Act authorizes BSER based only on measures applied at the source to make it cleaner, not measures requiring a transition away from that source of that type of power generation. In other words, they can require plants to clean up what's coming out of their smokestack, get new technology, have cleaner processes and so forth, but they can't require them to shift away, say, from coal to solar. And this means that the majority thought that the EPA had overreached, that the power located, quote, in the vague language of an ancillary provision of which they're talking about Section 111D of the Clean Air Act, had rarely been used this way. The regulatory program was one that Congress had conspicuously and repeatedly declined to enact itself. And I just want to talk about that for a second, because this is an argument that comes up a lot in administrative law cases, where the agency decides to do something new that they haven't done before, and maybe it's kind of a drastic change in direction. Why do they do this all of a sudden? Well, because we have a new administration in the White House that's trying to fulfill their campaign promises and so forth, or has different policy priorities that they campaigned on. And so, but the question is, if the agency is trying to do something brand new and saying we've been allowed to do this all along, we just never did before, but the very thing they're trying to do had been introduced as a bill or a statute in Congress many times previously, and Congress would never go for it, and they could never get the votes, then some members of the court will say that that's evidence that Congress wouldn't have intended the agency to do what they wouldn't pass themselves. In other words, the sort of implication is whatever the authority Congress intended to delegate to the agency is things that they would have done themselves if they had the time and expertise and so forth. But if they've actually considered a specific proposal and have said no thanks repeatedly, then it's more makes you wonder if that's what the Congress intended the agency to do. On the other hand, this is obviously sort of an argument from silence. There's a whole bunch of reasons that bills that might be very popular never really come to the floor of Congress. And so in some ways, this is a really attenuated form of relying on legislative history here to argue about bills that were never even passed and never enacted, failed bills, and using failed bills as evidence of what Congress probably wouldn't want the agency to do. This case solidifies the Supreme Court's jurisprudence on the Major Questions Doctrine. They're basically requiring clear, express congressional authorization for executive branch agencies to take actions that have such significant consequence. For the majority, in this case, note that they say that the Major Questions Doctrine is a distinct approach to statutory interpretation for extraordinary cases. In other words, cases where the stakes are this high. For those of you who kind of like to highlight good quotes from your casebook, I pulled out a quote from the majority opinion that I thought was good here. The Major Questions Doctrine is triggered when an agency asserts authority with significant, quote, history and breadth and considerable, quote, economic and political significance. Now, that sounds specific, but if you think about it, it's really not. Well, what does that mean? What counts as having a lot of economic and political significance? In such cases, courts should hesitate, it says, before concluding that Congress delegated such power through, they use phrases like modest words, vague terms, or subtle devices. In other words, we're reading too much into one sort of cryptic or ambiguous phrase in the statute, and that's the problem here. The majority here is requiring clear congressional authorization for the EPA's claimed power more than sort of merely a plausible textual basis. In other words, unlike most statutory interpretation cases, it's not enough for the agency to say that their interpretation is plausible or reasonable. The court's saying, if you're going to do something this drastic, we want to see that it's express in the statute that this is what Congress had in mind. The majority says that the EPA was claiming for itself an unheralded power from a statute that had been around for many decades, a long extant statute. And this was a sort of a transformative expansion of the EPA's authority, the power to substantially restructure the American energy markets. In West Virginia versus EPA, we have a dissenting opinion from Justice Kagan that's at least worth knowing about, because you should be aware that Major Questions Doctrine is still a hotly debated point, even among the members of the Supreme Court. And even on the two blocks of the court, the conservatives and the liberals, they seem to have different ideas about what it means. So Justice Kagan says that it's not really supposed to be a separate or standalone doctrine. It's just plain old statutory interpretation or common sense. Major Questions Doctrine is really just saying that, almost like an absurdity doctrine, if Congress really wanted to do something radical, that we want to see it in the statute. And she points out that Major Questions Doctrine cases from past years that the majority cites in this case had involved agency actions that were really the agency stepping out of its lane, where she calls it a misfit for both the agency and the statutory scheme. In other words, the agency was outside its traditional lane, or the action kind of conflicted with the statutory design that we have here. And then turning to the statute at issue in this case, Section 111 of the Clean Air Act, she observes, and this is true, that the language of the Clean Air Act, which was originally passed in the 70s, is capacious and system. Broad words like system are broad enough to include something like generation shifting, requiring power plants to diversify how they produce energy and have some of it coming from clean energy sources. And she points out that for a lot of our history, Congress has used broad delegations to agencies so that the agencies can respond to new and big problems like climate change. And this new program that the EPA had come up with was really just the EPA acting on carbon emissions from power plants. And the EPA, this is well within their area of expertise. So where does all this leave us? Well, the practical effect of the decision in this case was to limit the EPA's ability to regulate greenhouse gases from existing power plants using system-wide approaches. But the bigger question here, and the reason this case matters so much, is the Major Questions Doctrine. And critics say that this sort of newfangled Major Questions Doctrine basically allows the majority on the court to invalidate any policy they dislike. In other words, to have sort of a judicial veto. And to put it another way, the Major Questions Doctrine to its critics looks like judicial activism, if they can use it selectively against policies from a president from the other party, let's say. And there is some reason to think that's what's going on. I'm sympathetic to that argument. On the other hand, in statutory interpretation, as Justice Kagan acknowledges, we've always had a clear statement rule and a sort of an absurdity doctrine. And the Major Questions Doctrine does sort of embody some concerns about agency overreach and needing to have Congress make it clear if they want the agency to do something this drastic.
You know, we've been to 6 movies, 4 museums, a lecture on air pollution, and a pet show.
And that concludes our lecture about West Virginia versus EPA and the court's new jurisprudence in the Major Questions Doctrine.